refreshment centers, etc., etc. So with all of that in mind, I've basically looked at various structures in terms of which, in conjunction with Bellboy, we can be assistance to various body corporates and trustees, knowing full well that trustees have a job to do in the normal course of events. So let me start on the first issue, and that is the Occupational Health and Safety Act and its requirements. The minute the trustees of a body corporate engage an employment relationship with any person, then you have an obligation to take care for your employees. And that is kind of defined in terms by Section 8 of the Occupational Health and Safety Act. With the onset of the virus, many people from many walks of life, including trustees, have realized that the virus can give rise to various legal consequences, not to mention the fatal consequences of death. And for that reason, a lot of people have been galvanized in looking at health and safety protocols. Well, it's not just the virus. There are other issues that can challenge health and safety of the occupants of the units and also employees. So in this context, my delivery is in relation to health and safety matters, that the body corporate is in need of a plan, put it this way, a protocol. And in terms of that protocol, you are basically given the opportunity of taking such steps as is necessary to protect the occupants of the units, employees, and third parties who happen upon your premises against the virus. But not just the virus, also other dangers that may exist in the body corporate. By way of example, there may be electrical installations on the body corporate or in the body corporate. There may also be, in addition to electrical installations, swimming pools, there might be gyms, there might be other facilities that would produce a hazard for yourself, your fellow employees, and third parties. Now, many of you out there are going to say, yeah, but what's third parties got to do with this obligation? Well, the answer to that is very simple. Section 8 of the Health and Safety Act places an obligation on you as the employer, which will be a collective bunch of owners of the body corporate, to take the necessary steps to safeguard your employees, number one. Section 9, however, casts that obligation much wider, not just on employees, but also third parties. Enter tenants that occupy the units, enter contractors who come in to fix a water pipe, enter friends, family, aunts, cousins, nieces, distant relatives, whatever the case might be. That obligation extends not only to employees, but also third parties. So it is essential that in preparing a protocol, regard be had not only to corona, the virus and that, but also other infrastructures, other issues that may present themselves within the complex that will pose health and safety hurdles. For example, slippery stairs, slippery gangways, incomplete ramps, holes around the complex, that type of thing. What this proposal thus means is that there will be, in the first instance, an inspection of the body corporate from high up down to the base level, from the one side across to the other, to identify what specialists terms as potential hazards within the body corporate. That having been done, there needs to be a plan put into place to prevent those hazards and those risks from materializing. So the first thing that would be done on option one would be the preparation, would be the inspection. And after that inspection, a preparation of a hazard matrix, i.e. what is of concern, coupled with a protocol which will then assist you in addressing issues of health and safety. Thank you very much for putting that up on the side there. We're talking about package 1, health and safety compliance. So that protocol will then talk to you, and it will tell you exactly what steps you need to do to discharge your obligations as they flow from Section 8 and Section 9 of the Occupational Health and Safety Act. This is not going to be a 5,000-page protocol. It's going to be a punchy protocol, with key areas of address, which you will implement in the body corporate, and which the trustees will oversee for enforcement in consultation with Bellboy to the extent necessary. But once that protocol is in place, then at least one major step has been taken in the direction of safeguarding your premises for your employees as well as third parties. Pursuant to the inspection, there'll be the production of a protocol. Pursuant to the production of the protocol, we will then have an orientation and training session for the trustees, i.e., so that the trustees are fully on board of what their obligations are, statutorily speaking, and can have some peace at night knowing that if somebody comes knocking on their door and questions what they've done, they will be able to produce a protocol which, in more cases than not, will be well received by the Department of Labour and the South African Police Services should something happen on site. Now, you're going to say to me, well, I've got an indemnity that everybody signs when they come onto the site, so nobody's at risk. No, that indemnity is not a get out of jail card. That indemnity may help you in a civil lawsuit that may be around the corner, or may not, depending on how gross the problem is and how bad you've dropped the ball. So don't think that a signed indemnity form is your get out of jail card. It is not so. It certainly will not protect you against criminal prosecution. Now, I'm not running a fake news and fake alarmist type approach here. I'm mentioning simply to you what the obligations are in terms of the Health and Safety Act. So in consultation and discussion with Bellboy, we've come up with package 1, which is at a cost of 5,500 Rand plus VAT across the board for each and every scheme that wants to sign up. You will have the on-site inspection, you will have the production of a health and safety protocol, and you will have orientation and training on the protocol so you know how to maneuver your way through the various obligations. It will be something punchy and simple to manage. With that also comes the proposal that you will receive 30% discount on any knock-on legal services that may flow out of any incident that may happen in relation to the health and safety compliance package. Okay, so that's package number 1. Are we going to leave some questions till the end, or somebody want to engage me now, Shannon?
I think what we'll do, if anyone would like to pose any questions, please place them on the chat function and we will address them at the end.
Okay, thank you very much. So that's your the first package that we offer, and it doesn't only talk to the virus, because a lot of people are jumping around because of the virus, but it goes a little bit further than the virus, but it incorporates the virus naturally. Right. Package number 2 is also something that has come across my desk on more occasions than not, relative to employees in the body corporate scheme, and it's called Labour Relations Compliance. So just to give you an indication in general terms, how this starts is I receive a telephone call from the chairman of the trustees, and that chairman informs me he's got a supervisor who's out of control. This supervisor has got a clique of 4 or 5 people who he operates with on a daily basis, looks after them intently, but for the rest, he's aggressive, he's insubordinate, and he's not a team player, and he's causing a lot of ruptures with us. We want him fired, please. Okay, now it's difficult to put Humpty Dumpty together again when he's already fallen off the wall. And it's, as a lawyer, I'm a lawyer, I'm not a magician. So sometimes when you get to that point where you want to pull the trigger, you haven't set the foundation in place to facilitate a fair dismissal. And to move from consulting a lawyer to terminate the services of an employee through to the CCMA and the arbitration process can ultimately cost you up to 25,000, 30,000 Rand, okay? Depending on how angry the employee is and depending on how angry the trustees are at the end of the day. So I've looked at this scenario and then soon realized that particularly the bigger body corporates do employ employees. And the minute that happens, it can become a political nightmare to manage that employment relationship. So along the way, I have developed disciplinary codes for a body corporate setting what one would call contracts of employment for a body corporate setting, and held disciplinary inquiries within the context of a body corporate setting. So what package 2 envisages is that there will be an initial consultation with trustees. And that consultation will focus on how many employees and what do they do. Do you have contracts for those employees? And do you have a disciplinary code and procedure in terms of which you say to your employees what's accepted behavior and what's not? That creates certainty within that relationship and within that space. And it makes it that much easier going forward to effectively engage with the employee in a disciplinary context. So we start off on package 2 with a consultation process with the trustees. We move then to to review or compile a disciplinary code, as well as contracts of employment for your staff. And then thirdly, we will have an orientation and training session on the code, on the contract, and most importantly, on how to run a disciplinary process. You see, you don't need me to run the disciplinary process at that level, but most trustees ask me to do so because it's a foreign territory and everybody's nervous. The orientation process, excuse me, will not only give you the core understanding of what makes the labor relations tick, but it will also enable you to chair the inquiry, or to appoint another trustee to chair the inquiry, or however. So there will be a lot of information shared with you as a trustee to empower you in labor-related challenges. What then may happen is somewhere down the line, you might phone me and ask for some advice, or if things do go skew and you end up at the CCMA, to represent you at the CCMA. But at least my representation will not be against the backdrop of a nothing. It will be against the backdrop of a sustainable labor relations system, which would have been implemented into your body corporate post this engagement session. So effectively, package 2 means that you will get employment contracts for the employees, which we can tailor-make in consultation with your trustees, to a disciplinary code of procedure to say, look, you know what, this is Nazareth Home. And because it's Nazareth Home, you can't use the Lord's name in vain. Shouldn't anyway, but in other complexes, using the Lord's name in vain might be not a bigger expense as if you do it in Nazareth House, by way of example. So you may want to pick and choose that in this body corporate, these issues are of critical importance. For example, you might have a body corporate that is situated near a gang area or a drug area. So you'd want to say to your employees, drugs, out here. If you touch on one, you're out for whatever special circumstance. So you can tailor-make your disciplinary codes to talk to your area, your environment, the culture and the ethos that you find in your body corporate to sustain the integrity of that body corporate and what you want done by your employees. So it controls the situation and it avoids, well, we'll have to manage that, but it would avoid an employee favoring some members and not others. You'll have reporting lines and stuff like that. And then, of course, you'll have the training session. So that's at a cost of 3.8 plus VAT per scheme. All right. Then your third package effectively is a combination of package 1 and package 2. So you get both package 1 and package 2 at a cost of 6,500 Rand plus VAT per scheme. Now let me assure you of something. If you have one unfair dismissal case on your desk, that can cost you alone through lawyering fees 20 to 30,000 Rand in a heartbeat. So with this initial cost, in terms of labor-related matters, you certainly will have a tighter shop, better housekeeping around the fringes as far as labor matter is concerned, a working understanding of how to do disciplinary processes. And should you need me after that, you will get me at 30% discount for any legal services that may fly out of any disciplinary action that you may have instituted one way or the other. And that 30% discount will also be lawyer related. So if it's me, my hourly rate is X. If it's my professional assistant, hourly rate is Y. If it's the candidate attorney, hourly rate is Z. So it will be 30% of whatever that rate is. But you will get the benefit of that discount going forward. So that's effectively what the packages entail. And that's pretty much it. For me, package 3 would give you a very well-balanced approach to two critical issues in labor relations at the moment, namely health and safety, which has been pushed to the front because of the virus, and a tidy employment relation scheme in terms of which there are contracts, there's disciplinary codes, and there's an understanding of how to hold and execute a disciplinary process and consequences if you get it wrong. So that is the presentation, which has been thought out over a month, and we've looked at various angles to run, but we do think that that is of value to you, and we believe that the prices are very competitive as well. Thank you. Okay, any questions will be addressed.
Okay, thank you, Craig. I think you can stop sharing the presentation now, William. We can go back to Craig. If there are any questions, please will all attendees place those on the chat function. Craig, I have one question already. It's just asking you to please explain the position relevant to the employment of foreigners in South Africa.
Okay, so, okay, what I'm about to say comes from personal experience, and this is what I have discovered, is that generally when employers employ foreigners, they feel that they don't have to be rigid in applying the rules pertaining to the Basic Conditions of Employment Act and the Labour Relations Act. The reality of the situation is that the only requirement for an employee to have cover in terms of the Basic Conditions of Employment Act, or protection, not cover, and the Labour Relations Act, is that there is an employment relationship. That there's a foreigner is neither here nor there in terms of labour legislation. There's a whole host of other legislation that has to be addressed to make sure the foreigner is validly and legally employed and living in South Africa to start with. That's a different issue. But when you manage them from a labour relations perspective, they are entitled to every single right that a South African employee will be entitled to. And herein lies the rub. They know that. And they push that envelope. And more often than not, you find employers being caught, well, the Afrikaans expressions here, which I won't repeat now, but effectively being caught with his pants down because they didn't expect the challenge, and because they thought, unfortunately, that they'd have a one-upmanship over the employee because he's a foreigner. No, they will get the equal protection in the eyes of the law, notwithstanding that they are a foreigner. You may want to address them, though, if they do become problematic, and you should have this covered up front, is their work permits. And if they don't have their work permits, you can consider retrenching them because you can argue that I don't want to keep an unlawful immigrant in my employer. That's a different issue. Again, it's a procedure to follow. But the bottom line is they are equally entitled to rights, as in, even if they are unlawfully employed, they are still entitled to that protection. Okay.
Okay, Craig, and if you could just briefly touch on the employment. I know a lot of people say, okay, I only employ a casual. I don't have to comply with all of this. If you could just touch on, I know that before you've said that there's no such thing as a casual. So if I can just get your opinion on that, please.
Let me put it this way. Casuals are a dying phenomenon in labor relation terms. You can't be half pregnant. You're either an employee or you're not. And the only importance of being a casual, in inverted commas, depending on the number of hours you work, is that that employee may or may not access certain benefits in terms of the Basic Conditions of Employment Act. But it doesn't mean that he cannot be unfairly dismissed. It doesn't mean that he cannot be subjected to unfair labor practices or to discriminatory practices. So the message is that people use the label casual as a means to escape the Basic Conditions of Employment Act and as a means to escape the Labour Relations Act. No, you're just setting yourself up for a challenge down the line, because you're going to get to the CCMA and you're going to say, I gave him notice, but in any event, he's a casual. No, you still got to say why you're terminating his services. You've still got to follow a procedure and have a good reason to do so. So the manner in which casuals were employed and utilized in the 80s and 90s is pretty much a thing of the past.
Okay, thank you. There has been obviously a lot of information disseminated with regards to how they manage COVID-19. For example, I know there's a question now just been placed to say if a staff member is sent for a COVID test, does the waiting period become sick leave? Could you just address these issues quickly for the attendees?
Okay. Number one, the first thing we have to understand about this virus is that not all the specialists and doctors who know how actually know how. This virus will change, it will mutate, and so too will the precautionary mechanisms that you'll have to implement from day to day probably change going forward as more and more is unraveled regarding this virus. So it will be very much a living product. To answer the specific question here is that the government has willed it and wished it upon all employers that if you're going to send an employee home for precautionary isolation, okay, say again, if you're going to send an employee home for precautionary isolation, then it is best in those circumstances to effectively regard his or her absence as sick leave. It's going to get tight when the sick leave is exhausted, because then no work, no pay would be applicable. So yes, it is fitting to apply sick leave because that's why you're sending the person home, regardless, and this is the funny bit, regardless of whether or not that employee is positive. Okay, so it will be recognized as sick leave if you exclude somebody from the workplace because you are worried about the virus and the infection of the virus. There's enough of a connection there between illness and whatever to say that you can follow sick leave for that. It is a difficult story to establish whether that virus was in fact an IOD, injury on duty. Because if it's an injury on duty and there's extended periods that you are off, well, it could be considered as an IOD going forward, and that would mean that at some point in time, the compensation commissioner will take over 70% of the salary if the individual is struggling to recover somewhere down the line. But for present purposes, your default position is regarded as sick leave, and you can analyze later whether or not it would qualify for IOD leave, okay? Because it's very difficult to pin down where you get this virus from. Who knows? Especially with people being asymptomatic and being able to pass it over in that phase. Let me also just say this. What is also very important is that employees in general terms follow all these precautions that are established for them. Because if they flout those precautions and hold parties in their unit, for example, okay, and don't practice social distancing, then you're going to find a situation where if the employee is party to flouting those rules, that could be a dismissible offense. Okay. I've had 2 inquiries in this where one employee reported back to the employer that she'd been in contact with a COVID positive test at her doctor's surgery. It turned out to be a lie. She just wanted 14 days at home. And that's dismissible because it's dishonest. That's on the other side of the equation. Okay. So again, the protocol would serve as a baseline to institute disciplinary action for inappropriate deviations from that protocol.
Okay, so the employee is then with the employer is within their right to ask for proof that they've been in contact with someone with COVID.
Yes, they could request it, but obviously you're going to err on the side of caution here. But if you doubt it and you pick up something, you can ask for that in terms of an inquiry. My default position would be fine. Go home, and send us proof of the person who you've been in contact with, and we'll consider it. You can reserve the right to hold an inquiry after the quarantine period, which is exactly what I advised another client. They had their doubts about this. We validated the fact that she was not exposed to anybody who tested positive. We took a deposition from the doctor, and on the expiry of the 2-week period, we arraigned her at a disciplinary inquiry and fired her. Unfortunately, that sounds a bit clinical, but it is what it is. She lied and took 14 days at home. So yes, again, you can be disciplined for it. Okay.
And obviously, Craig, if they don't have sick leave available?
No week, no pay. No work, no pay. If they've exhausted sick leave, it's no work, no pay. There's no obligation on an employer to pay somebody who is COVID related. Okay, in that context, if you can't work, you can't pay, especially in the lockdown period. Okay, it's not there. But now that the lockdown is being lifted and people are starting to return to work, but your employer then intentionally says to employees, stay at home, that's a different issue. Okay, then you're starting to work towards operational requirement terminations and things like that. So, but the bottom line is, if all your sick leave is ventilated and finished, and there's no case to be made out for an injury on duty, okay, if you follow what I'm saying, then no work, no pay.
Okay, does the body corporate have an obligation to pay for that test? Should they be sent home in case?
No, there is nothing that I've seen in any of the legislation that compels an employer to pay for the medical testing. What I have seen in the protocols is that an employer must get the employee to be tested. It doesn't say that the employer must pay for the test. That's my read of the situation. Some employers may do that voluntarily. Some employers, big enough, might have a medical persona on site. So no, but there's no specific obligation of an employer to pay for the test of an employee.
Okay, thank you. I've got a question here to ask that if the trustees have issued an instruction to staff that they may not register complaints with members of the body corporate, nor ask those members for loans, and if that instruction is disobeyed, would that be reason to issue a disciplinary note?
Well, now let me put it to you this way, without sounding like an insurance salesman. Firstly, that would be something that doesn't necessarily strike as being misconduct. But once you begin to analyze it, you see that it does amount to misconduct. I've been down this line before. Supervisor at one of these big shopping complexes was lending money to fellow employees. And when it came payday, he'd go around into the pay packets and start taking their money. Now you can already see the conflict that's going to develop between a supervisor and his employees when money passes hands. So when you first think of this thing, you don't see it as misconduct. But when you begin to analyze it, if these employees are loaning monies from members of the body corporate and don't repay that money, there's going to be conflict between that employee and that member of the body corporate. So whilst it seems like a fairly innocuous kind of offense, it's not, because it does lead to relationship issues. And if there's one loan once, you set up a pattern, then it's going to be another one and another one. Then the other one's going to come around and say, no, I don't have money for you. There's going to be conflict. So how you deal with this matter is in your code that I'm proposing, you will record specifically that you are not to approach any member, any trustee, any chairperson of the trust, or any person whatsoever to loan money. Okay? It is prohibited, and should you do so, it would be visited with the following. 1, final written warning. And if you repeat it, dismissal. Unless you view it in your body corporate as so serious offense first off that it's dismissal. But it will be difficult to defend a dismissal on a once-off case in these circumstances, unless you've made it clear in the disciplinary code that this is a no-go zone. I'll give you an example. To smoke in a mine is a no-go zone. To find cigarettes in a mine that's unlit is a no-go zone. To find a box of matches in a mine is a no-go zone. So if you go down a lift into a mine and you found a box of matches on you, notwithstanding the fact that you haven't used them, you got the box of, it's dismissible. Okay. Because 100 people died in mining incident in that year. So you can set in your code the tone that you want for disciplinary action. So if your code says this is gross misconduct and penalizable with dismissal, then you're okay. But if you don't have a code and you haven't stipulated it very clearly that this is dismissal, it will be very harsh to dismiss this employee first off. You'd have to color it in with an element of insubordination. You were told not to do this and you went to go ahead and did it anyway. But insubordination, once off, is not grounds for dismissal, unless it's very gross or repeated in nature. So to answer this issue simply, yes, you can dismiss. In this instance, though, I would say issue a final written warning, then followed by the next repeat incident by dismissal, and use the time to create a rule which says, whilst we've done it as a final written warning now, going forward, for each and every one of you, you will be dismissed if you disobey this rule because of the effect on
questions I posed to Craig to Labour matters only. If you could please just let me know, Craig, what body corporate's obligations are with regards to Compensation Commission and UIF.
Compensation Commission and UIF. Well, let me answer the question generally. If I understand it, I'm taking a flyer here. But in my mind, it means the following, that if you got employees, there needs to be registration for UIF. And if you've got employees, there needs to be registration with the Compensation Commissioner. So there will be monies paid over to the Compensation Commissioner in terms of their assessments, and there will be monies deducted for UIF and paid over to the Department of Labour, to whoever it's paid to the fund for purposes of UIF. The key factor there is an employment relationship. No employees, no compensation. And understand this, it's always better to be registered with the Compensation Commissioner, because then if there is an injury on duty, that employee's claim for cutting his hand off, his finger off, or whatever the case might be, is a claim he enjoys against the Compensation Commissioner, not against the body corporate. Okay, so he won't be able to sue the body corporate, but make sure he's got the insurance that is covered from Compensation Commissioner for it. So that, I think that makes sense. I hope it does make sense, but yes, you would have to resign and pay, you know, what your requirements are. Both forms of insurance, different for different grounds. Okay.
Yeah. I think the last question we're going to pose for today is just, should contracts be reviewed regularly and updated in terms of the changing environment, and would this form part of your package?
Yeah, the first point is this. It does serve everybody well to review your contracts of employment. Certain things do change from year to year as legislation changes and so on. So an annual review is advisable at whatever level. Certainly, insofar as it concerns the terms of the contract, as well as the disciplinary code and procedure, and so too also your health and safety protocol. By way of example, it may be discovered that the coronavirus is capable of infection via water. Okay, so that might need a different precaution. Right now, we don't know. Okay, but let's assume that does arrive. So you'll have to adjust your protocol going forward by incorporating a clause to deal with any amendment in protocols or any adjustment in the science on how that thing does. So yes, I do advocate an annual review on your package, and I would also advocate a review on your protocols to the extent necessary. Yes, we can incorporate that in terms of the proposal. I would say that the first review would be incorporated in the initial packages that are there. Any subsequent reviews, though, in years 2, 3, 4, 5, 6 going forward, should you want it, we could then look at the discounted rate provided in the package of 30%. So I'm happy to do the first review in a year's time on the house, so to speak, as part of the package. Any reviews after that, we'd look at a 30% discount of the fees associated with it. But once the wheel has been invented, you don't have to reinvent it. So the amount of time you're looking at a review process is 1/10 of a creation process, if that makes sense.
Okay, great. Thank you very much, Craig. I'm sure that our attendees have found the information beneficial. And again, if anyone has any additional queries or wants more information on the packages, please make contact with your portfolio managers. Okay, thank you,
I'm still
Craig.
good if there's any other questions there. I'm still good. I'm not in a rush, but it's up to you. Okay.
Okay.
Are we done?
No, I think that's it. That's the questions that have been asked. Okay.
Okay. All right. Good. Thanks. Ta-ta.
Thanks, Craig. Thank you,
Bye-bye.
everybody.
Bye.
Bye.